All right, so we might get underway. I'm sure there'll be a few people joining shortly, but we'll get underway just in case anyone's pressed for time. Thank you for coming along to our latest webinar. This topic being the topic of redundancy, which is often a perennial issue for electrical contractors. Work can be cyclical, comes and goes. We need to understand how to grow our workforce. Putting people on is the easy part often, but then also how to appropriately reduce our workforces when that work either finishes or there's less demand for our services. So we're going to explore the Fair Work Act and what its and the awards and what the obligations are with respect to the concept of redundancy, what it means, what it is, what it isn't, and that process that's attached to that. So the session will talk about what is redundancy. That might sound like the obvious start, but it's the starting point. We need to understand what the concept of redundancy is prior to really launching off, some scenarios which are commonplace. Consultation, what that means, what it looks like. Consultation can be a bit of a funny thing because it can often be, how long is a piece of string? In terms of what is appropriate given the circumstances, given the workers to be affected, those sorts of things. The redundancy process, it's not a matter of simply walking into a room and handing someone a letter. That's not a process, that's not consultation. So what is the redundancy process? We'll also talk about issues around redeployment and what an employer's obligations look like in that area. And a key concept around selection criteria. The redundancy can often result in termination. An employer needs to be in the best position to be able to defend itself against a claim, whether that claim is an unfair dismissal type claim or whether that's a general protections type claim. And in a general protections type claim where an employee says the employer's selected them for an unlawful reason, being able to rely on quality and merit-based selection criteria is an important part of being able to defend that sort of claim. And as always, we're seeing the rise and rise of claims. They're not something that seem to be going away. So the boring legislation stuff to begin with. Redundancy occurs when an employer no longer requires the person's job to be performed by anyone because of changes to the operational requirements of the employer's enterprise and, critically and this points to some of our process elements later, the employer has complied with any obligation in a modern award or enterprise agreement to consult about the redundancy. And this includes things around suitable or conversations around suitable alternative employment and what that might look like, what those might be. There's a number of elements which we'll go over in terms of that concept. But firstly, that concept of the employer no longer requires the job to be performed. Typically, though, what we see, and I do have some examples which we'll get to, but where there's a downturn in work, oftentimes, and I get this a lot from our members, typically our members are that, between 1 to 5 employees. That's a vast majority of our members. So it's not uncommon for a business to ramp up for a particular project or while work is sort of booming in the area. And then when it subsides, that the employer has to, perhaps because of point 3, as a downturn in work, the director may decide, well, I'm going to go back on the tools. There's no better person in the organisation to promote the business than me. I would say a lot of our members say that they're the electrical quality standard in their organisation, and that they can get around and promote their business through their work and by being out and about amongst the builders, the clients, those sorts of things, and ensure those relationships are ongoing. So it's a common scenario. And only going back on the tools can prompt, or a shift in work can prompt restructure of the business, and therefore of the workforce. If there's less work coming in, the business might say, well, I need less of a back office support. So while I need the workers on the tools still at this present time, or that amount of work is manageable, the size of the workforce back of shop in the administration, or maybe a sales position or a warehouse position, that's not at the same level. I've restructured the work. The employees will be doing more of their own stock control warehouse work, or maybe they're just allowed to go to the supplier themselves now, as opposed to having someone dedicated to manage that. And scheduling of work, maybe the owner is doing the scheduling rather than having a scheduler there. So it doesn't necessarily mean we're displacing the electrical workers. We might be looking at the back of shop, as I say, position. Not a completing project with no new projects. There's another common scenario in which redundancies may result. And of course, if the business was to be wound up, then often that would result in the business in redundancies, unless there is a sale of a business. In terms of consultation, this is a critical step, which is a process side of things. So the previous slides, I guess we're talking about the meaning of redundancy. Redundancy is not just simply the natural turnover. Redundancy can be where the employer decides, well, I don't need work to be done by someone, or I'm going to perhaps redistribute work, and that means a position is going to be no longer required. Those decisions are all valid. That's what's called the managerial prerogative. An employer gets to make those sorts of decisions. Consultation, as I say, it's a how long is a piece of string kind of question. People have different views, particularly unions. Consultation in their minds often means agreement, and that might spill over to the way workers see the consultation process. But consultation is not agreement. Consultation is the ability for employees to be informed of the changes to the business, the reasons for the change, what mitigating steps the business has put in place in order to avoid something as as drastic, let's be frank, as drastic as termination of employment, and also an opportunity to influence, not to simply hold up a stop sign and say, look, I don't want to get made redundant, that's really inconvenient for me. Of course it is. It's a question of influencing aspects. Sometimes consultation might include the employer asking workers if they have a view about voluntary redundancies, if anyone wants to put their own hand up. It's not uncommon for workers to go, well, I'm going to start my own electrical contracting business, give me the notice period and perhaps any severance that's applicable, and I'll go on my merry way and start things off. So, calling for voluntary redundancies is not a bad approach as part of the consultation process. So consultation is not simply informing the employees that the company's made a decision and that 1, 2, 3, 4 workers are going to go. Consultation is as I say, talking about telling the story. Where is the business up to? What is the nature of work? What is the nature of the prospects for more work? What has occurred? The decisions from the Fair Work Commission have shown us that at the very least, the employer needs to put some level of breathing space, some daylight, some separation, if you like, between the consultation process and the decision to terminate someone as a result of the employer's right to make a person redundant and retrench them, terminate them as a result. We say that looks at least 2 meetings. The first meeting, the position, the company's proposal, what it says it should occur, including any discussions around selection criteria, suitable alternative employment, or what that might look like. That should happen in the first meeting, and then the second meeting is a consideration of what the employee views. Obviously, as I say, not everyone wants to get no one particularly wants to get made redundant. That's not helpful for them usually. So it's a case of having receiving that feedback from the worker. Oftentimes employers, particularly the smaller members, will say, look, this is a fait accompli. I have no choice. I don't have different departments. I don't have different areas, or if I'm looking at an apprentice to be made redundant, this person can't be redeployed to something else. It just doesn't, they're not a skilled worker, they're a trainee. That may well be the case, but it's still appropriate to consider to go through the consultation process. If for no other reason, then the award tells us to. And if we want to be able to defend ourselves later, we need to have done this process. That's what I refer to in that point 4 there. A failure to implement a proper consultation procedure may result in a successful claim of unfair dismissal. Section 389 of the Fair Work Act talks about what is the meaning of genuine redundancy. It talks about that definition of no longer requiring the position to be done, and that was why it was bold and highlighted and underlined, and they've met the consultation requirements of the award. Clause 8 of our award. That when I say our award, I don't mean the MEA award, I mean the Electrical, Electronic and Communication Contracting Award, or any enterprise agreement is a requirement to have a major workplace change or a consultation type clause. So award or EBA covered employers need to have done this first step. Consultation also, we need to be mindful, it shouldn't be designed to create uncertainty. The consultation process is going to be, by its very nature, a bit of a morale blow and will create uncertainty. So it's always my advice that the employer is clear with respect to timeframes, when decisions are going to be made, when the process is going to be wrapped up, in order to alleviate as much as possible the uncertainty. It's not appropriate in most consultation processes to simply say, well, we're going to be selecting these types of workers or people who have been on for the shortest period of time, because obviously everyone shuffles away from the person that points to. So when we talk about consultation, particularly if we do things in a group setting, which might be the appropriate first place, we don't start by saying, this is going to be our selection criteria. The company may say, we're going to be working on selection criteria that is going to give us the best team going forward, the strongest team going forward, because obviously that presents us with the most capable and able and flexible workforce to be able to win work, do work efficiently. So that can be a process. Then with the individual workers, as a result of that selection criteria, which may need to be, the criteria itself may need to be formalized, may be something that's fairly obvious, but given the circumstances, that conversation can be held with the worker. And we'll get to severance components and payouts and those sorts of things later, but I just want to be clear there that the small businesses are not exempt from the obligation to consult with workers around redundancy. They may be exempt from the obligation to pay severance, but that doesn't reduce these obligations around consultation. If you have any questions as we're going, feel free to use the chat service, any little scenarios that we can talk about in general. If it's something too in-depth or perhaps relates to you, we can take it offline later, but by all means feel free to pop any questions into that chat facility there if you've got them going along as we go along. I just have a question here from Julie. In terms of the exemption for small business paying severance, in short, and I'll get to some of the finer points of this later, if a business is a small business within the meaning of the Fair Work Act, which is fewer than 15 employees, then it is not required to pay the severance component. It's always required to deal with the notice, that is either given notice and it's worked out, or that the notice period is paid in lieu. But the severance component, which is separate and not worked, it is simply a payment made to the worker, is exempt for small businesses. It's also exempt for employees with less than 12 months service, and apprentices. Generally, at least under the modern award and the national employment standards, they're not entitled to the severance components. Some enterprise agreements, particularly ETU, EBAs and the like, they do have severance entitlements over and above the national employment standards, which would be applicable, which do apply to apprentices. I've got a question from Elena as well around the consultation process and whether or not we can suspend work during the consultation process to prevent someone developing a suspicious or conveniently timed work cover claim. If the workers are going to be suspended, if you like, because there isn't any work, that's fine, but the employer still has an obligation to pay those workers until the completion of the consultation process and the finalisation of the redundancy. So you could potentially say, look, ladies and gents, we've got no work today. We'll pay you. We're going to hold a meeting this afternoon, but you don't need to attend work until that particular meeting. That is fine. Typically, though, that's not necessary. But I've certainly had instances where employers have been, particularly concerned about that. But it's not a case that the workers can simply be suspended without pay while the work isn't available. It's a requirement that they're paid their ordinary hours until a decision, perhaps, to terminate their employment. It's not uncommon for businesses to ask, and critical part there being ask, workers to take a period of leave, perhaps, in order to stave off any decision to make positions redundant. But obviously, when we're talking about redundancy at this point, we might have exhausted those sorts of approaches. But certainly, a point to be made is that prior to any decision to go through the consultation or redundancy process, the business would often, doesn't have to, doesn't usually even, may be the way the circumstances fall, but it may say to workers, look, we're having a downturn in work, or we're struggling to find work. We're asking if people would take perhaps rolling periods of leave in order to alleviate the strain on the business, so that we can determine what needs to happen. So the selection criteria of a redundancy process is an important element, particularly where we're looking at like for like type situations. That's what I refer to there in point 5. We might be picking apples, as in comparing apples with apples. If we've got 5 tradespersons and when we need to reduce that to 4, for instance, then having a selection criteria or determining some differentiating qualities is an important element. A selection criteria shouldn't be discriminatory, and what we mean by that is based on a discriminatory attribute, where we're picking the older workers, we're picking female workers, or something along those lines. Those sorts of examples might sound obvious or extreme, but we also need to make sure that our criteria doesn't indirectly point towards a particular group. What happened in one instance where a business applied the last in, first off scenario, which is not illegal, I might point out, as their selection criteria, they inadvertently and indirectly made a group of workers redundant based on a discriminatory attribute, which was the fact that they were all female. So obviously that didn't go very well, because their criteria, their selection criteria, being last in, first off, meant that a group of female workers were the ones who were going to be selected. It wasn't directly discriminating, it wasn't their intention, but it was what was the result. Merit-based selection criteria would be things like, we're looking at maybe the business holds high-value skills and competencies like dual trading. If you've got workers who are dual traded, if you have workers who can run jobs, order materials, those sorts of things, those would be what we call merit-based criteria. We need to seek to answer the question around of why me, and employers often seek to use things like performance-based measures. We want to select this worker because they're the weakest performer. If we're going to do that, we need to have the evidence of that underperformance. We need the criteria to be measurable, because if push comes to shove, or we're at the pointy end at the commission, we need to be able to rely on those things. And if we simply state to the worker, we're selecting you because you're the weakest performer, perhaps a little bit more tactfully than that, they're going to want to know why, or they're going to need to have the evidence and examples of that. So a redundancy process isn't isn't a replacement for an appropriately managed performance or disciplinary process. The selection criteria, as I sort of indicate in 4 there, it may be simple. It may be there's one other worker or 2 other workers, and of those 2 other workers, one of them is the son or brother of the business owner, and the owner is going to come back on the tools. It's perfectly okay for the business to say, we're going to hold on to the shareholders of the business. I'm not going to make myself redundant in order to keep a worker employed. That would not make sense, even business sense or otherwise. So we can rely on things like the owner's going back on the tools, or the son is going to continue on in this position because they've got a view to passing the business on to them. Those are a fine basis for a selection criteria. But again, consultation and redundancy processes, we're looking at this as a general topic and all the different possibilities that can go with and scenarios that can occur where a business is looking to reduce its workforce. So here we have an example, what we often call what I call a skills matrix or a selection criteria matrix, where we look at some things that help us score our strongest performers and then down to our most valued candidates, and then down to the least valued. That sounds like a judgment call on a worker. You might have someone who's a great worker, but if they don't tick enough of the boxes for you, they're going to score the lowest. And if these criteria here, as I've got unrestricted license, they've also a dual traded, so they hold a refrigeration ticket, maybe they can do high voltage work or have experience there, and they hold an open cable license for their data and comm stuff, the ability to lead jobs. Those are criteria which you might score a worker, either with an X or a literal score. You might say, well, out of 5, where does each person sit? And then at the end of the column or end of the row, you might then add up the score that worker has, or look at the number of boxes the person has ticked and say, well, look, these are sorting them by most number of boxes or highest score. That's how we've come to determine who are the people we're going to keep and who represents the people who don't give us the best value proposition, the highest skill going forward. So that's an example there. May be necessary, may be helpful, may not be helpful. Certainly something that you would take to a meeting, not necessarily identified in this way in terms of employee A, B, C, D. Even though it's de-identified in this example, that may be enough for the worker to determine who the other workers are and cause a little bit of a awkwardness. But certainly their own score across, here's what we view the important criteria to be. Here's how you scored against those. That can be a helpful conversation point as part of your redundancy process. Something you might give them an opportunity to respond to consider your assessment. That shows you've gone through the consultation element appropriately, and you can clearly demonstrate there that the selection criteria, provided you use things like these, are measurable and that they're non-discriminatory. And that's helpful to be able to defend the business itself at a later time if necessary. Any more questions just before I get into the concept of redeployment? All right, so redeployment, as the first point there indicates, there's an obligation on the employer to at least consider that. I often say to employers, even the smallest of employers, state the obvious. If there is no suitable alternative employment or some other option, say so. We've considered what else we could do employment-wise. We've considered part-time positions, or we've considered your ability to do work in the warehouse or in the office, and we don't have a position there. Or we have a position, but we don't believe, and we've made our assessment that you don't fit the criteria or couldn't complete that role. That might be a discussion point for your consultation. but certainly it's important to discuss any suitable alternative employments. As the last point there suggests, could this job be performed on a part-time basis? Would the person accept that? Might the person put that to you, and it's something you need to consider? Um, Oftentimes when I've been having these discussions with members and I say, well, okay, you've got less work, what's the prospect of this person doing the work on a part-time basis? Even if the worker or the business is strongly of the view this worker is not going to accept that, it's not a reason not to put it to the person for them to then be able to say, well, no, I can't accept that position. Casual employment, which is another popular sort of one for employers to say, well, look, I don't have this full-time position, part-time, is not particularly highly used in the electrical contracting industry, but it could be. There's no reason why not, particularly if you had just less work. Casual employment. We'd say that casual employment doesn't particularly represent suitable alternative employment. Certainly doesn't bring about the end of someone's employment because they're still on the books as a casual, but because it's what is considered precarious employment, there's no obligation to offer ongoing hours, there's no guarantee of hours, there's no notice periods, annual leave, sick leave, those sorts of things. Casual employment is not really in the conversation when it comes to suitable alternative employment. If there's a possibility of it, certainly we would say offer it or put that out there. Person may want to accept it for a time while they find some other work, but it doesn't represent suitable alternative employment. One of the elements of the Act is around this suitable alternative employment and redeployment. If the business was to find work for this employee at another contractor, which is not uncommon, it's about what efforts the employer makes in obtaining the work. If you simply said, why don't you give Jono a call down the road, the employer hasn't obtained employment from another employer for that worker. They've done so off their own initiative. That might sound like a bit of an out of context kind of statement and not really along the lines of what we're talking about here, but later on we'll be talking about the ability for an employer to vary severance payments where severance is a requirement because the business has 15 or more employees, and that ability to vary because they've obtained or offered suitable alternative employment can be an important aspect for an employer. Just because an employee doesn't want to take some employment doesn't mean that they shouldn't, because it represents alternative employment, and doesn't mean that the employer should be up for the value of the full severance component. So that's a concept for later, but when we talk about redeployment, we're interested in the employer obtaining that employment. Okay, I've got a question from Julie. Thanks, Julie. If the business has an increase of work following a redundancy, does this worker, given the alternative duties, have a right to regain their previous position, or can the employer recruit other staff for the previous position? So I presume in this scenario, if someone has taken a new position or an alternative position, maybe they've taken on a scheduler type role, and then the business wants to put on a tradesperson position, do they have a right to go back to that tradesperson position? Not really, no. It might be a conversation worth having, depending on how well they're going at the suitable role. You know what you're going to get with respect to the electrical work. You're going to bring on someone new. You're not necessarily sure of what you're going to get. Presumably in this scenario, though, there's a little bit of a suggestion that this worker might not be the greatest electrical worker anymore or ever, and therefore they're much better suited to a role that's not directly on the tools. So when someone accepts alternative employment, no, they relinquish their what you might call otherwise a substantive position, that being the electrician role. They're going to put on this next one. Particularly if there is, however, a very short turnaround to needing this new position or new electrician, It is very much advised that the business puts the scenario to that worker, because we don't want to have allegations, at least, of a contrived scenario. You put me in this alternative position and then you immediately hire somebody else on. You didn't do that genuinely. You did that because you didn't want me on the tools anymore. They'd probably still struggle, given that they have accepted a new role and there has been no termination of employment, but we might get some disputes based on the general protections type area if the worker wants to allege that you've selected them for that because of a discriminatory attribute again. So there's nothing glaringly wrong with that sort of process, but it's something that you would, or scenario, but it is something you want to consider, the facts of the case and the timing and those sorts of things before, rather than just simply say, oh yeah, we'll be sweet. Elena has a question about the minimum time frame before we can rehire into a position that's been made redundant. There is no minimum time frame in the legislation. Again, it's going to be contextual based on what the timing of the decisions have been. The contrivedness can be another allegation we have to, or situation we have to defend against. If there's just like before, if there's a short period of time, we might find ourselves offering the work back to the original worker made redundant. Should be nothing wrong with that, because we're talking about a worker who otherwise was a good worker, or at least we haven't gone down the path of identifying that they're not a good worker. It's just simply a question of, is the position required by the employer anymore? If the answer is no, and then we have a situation where the employer does require the position again, then the answer should be, we should be looking at this person again. If they have a new job, fine. Then we can rehire into another position. But to just simply put an advertisement on Seek or just hire somebody new shortly after terminating someone would be a bad look, and could lead to some of those contrived allegations. In terms of timeframes that do exist, an employee can make an unfair dismissal claim within 21 days, or needs to make that claim within 21 days of being made redundant. So that gives us a little bit of an indication as to what the time frame might look like for us, to get some level of comfort or put some parameters around that lack of time frame. However, the Commission has approved extenuating circumstances and therefore extensions of time for applications where the employer has appeared to have contrived timings, as in on the 22nd day after the termination, the employer then advertised for the same type of position. The Commission went, hang on a second, we think there's at least an allegation or a claim here that's worth the Commission hearing before we make any decision as to whether or not it still meets the requirements of a genuine redundancy. Terry's got a question here. Are apprentices entitled to severance? No, apprentices are not entitled to severance under the National Employment Standards, regardless of whether they have 12 months or more. It's just if any worker has less than 12 months service, they're not entitled to severance payments. And if the company has less than 15 employees, there is no requirement to pay severance. So if the business, though, had 16 employees, to make our example easy, 4 of those were apprentices, it doesn't reduce the number of workers down to 12. There's still 16 employees, but if 4 of those people being made redundant were apprentices, they would not have an entitlement to severance. So one of the important terms in this area is retrenchment. It's not commonly used because people just like to rely on the term redundancy and apply it to simply all scenarios. But redundancy is really just about the position, and retrenchment occurs where we haven't been able to find any alternative employment. So the current position's been made redundant, we've had a look around, there's nothing available or that has been accepted, and then we make a termination a result of that. So that's what retrenchment is. Termination as a result of redundancy, and the decision to terminate needs to be confirmed in writing. We always advise that the decision is a summary of what's occurred so that you can rely on that as well in terms of describing the consultation, describing anything around offers of suitable alternative employment and why they, or consideration that the employee said, well, I'd like to do this part-time. You've put back, no, you can't do that for the following reasons. Let's summarise that in our determination letter. So some more points here on the determining small business threshold. So we've covered these a couple of times, so you should be able to answer these for me. But one of the areas that's commonly not first considered are the last 2 points there. Working directors who draw a wage, they're counted in the 15, and employees of an associated entity. So if the business has another business, then the count is across those associated entities. And the associated entities, it can be a complicated area, because it relies on the Corporations Act and definitions there as to who is an associated entity. Effectively, though, if we've got common directors across different PTY LTDs or entities of other types, then we should start to pause and have a look at how many employees are across these different entities, because it's no way to avoid the obligations around severance by simply carving up your business into 4 businesses. Maybe you've got a commercial business, an industrial business, a solar business, an aircon business. They would all be considered together. It doesn't compartmentalise them and avoid these sorts of conditions. Casual employees can be a tricky one as well. And these are oftentimes situations where an employer is looking to go through what's called a jurisdictional objection, because a worker might say, well, this casual employee should be counted, and the business might say, well, no, this casual employee shouldn't be counted as part of our 15 because their work is very irregular and it doesn't occur on a regular or systematic basis. But if a casual is working, whether it be 5 hours or 30 hours, but each week, then you would say that they are a regular and systematic worker, and therefore should be counted. So if you do fall into that category of something other than a small business, and because of either associated entities or by virtue of being the working director and it puts you over that threshold, the National Employment Standards looks like, for severance, the entitlements look like this. So this is not a notice period. This is in addition to that. This is a payment simply made to the worker based on their ordinary wage. It also doesn't take into account, as the note says there, any particular enterprise agreement provisions. What we've had previously is state-based severance tables like this one, which do look a bit different, particularly when we get to that last one there, at least 10 years of service, where we have 12 weeks. There, people oftentimes will say, hang on a second, Jordan, I think you've got an error on your table. This is the federal standard when it comes to redundancy. The previous, well, the rationale, which is a little bit dated now, but it's based on older term conditions that existed, is that after 10 years of service, a worker was entitled to receive their long service leave payout in all jurisdictions. And there was no such thing as pro rata entitlements between 7 and 10 years where the person was made redundant. So if someone was made redundant now, given these pro rata conditions, after 9 years, they'd get to 16 weeks plus pretty close to the 8.667 weeks they would get for long service leave. So they're clearly in an advantage to someone who gets made redundant after 10 years, where they only get 12 weeks plus the 8.667 weeks fully. But there's been no appetite to review or change that, so employers are left with that. We're certainly looking at, if someone's been with the business for their apprenticeship and then a couple of years, we're looking at potentially, between 5 and 7 years. So we're looking at sort of between 10 and 11 weeks on top of the notice period of 4 weeks, unless the worker is over 45 years of age, and then they get an additional week as well. So it's not a decision that's going to come lightly to a business a larger business, and it does pay to look around and see what we can be looking at in terms of selection criteria, maybe going more for those sort of last in first off type scenarios rather than those workers who might cost money to retrench. So I mentioned earlier that there's a possibility of varying redundancy payments. This is something that can only occur by application to the Fair Work Commission, not a decision that an employer can come to on their own. The circumstances need to be that the employer has offered suitable alternative employment and that the worker has then turned that down. The employer would then say, well, okay, we think that there's going to be we think that this offer has been turned down unreasonably. It represents suitable alternative employment, and therefore we're going to apply to the Commission to reduce that amount. They're not going to reduce it to zero, almost ever, unless there's a demonstration that is basically exactly the same position, perhaps just in a slightly different area. And if that area is not substantially substantially far away, then the employee is going to have a really tough time saying why that they should hold on to their full severance entitlement. But I must say, I've never had an employer actually go down the line of seeking a variation to a redundancy payment, probably by virtue of the fact that most of our members are smaller businesses and don't fall into this area. But oftentimes they might have made the decision for their own reasons to simply not contest, or there just hasn't been an offer of suitable alternative employment available anyway. But the Fair Work Commission, when they look at these sorts of matters, they'll have a look at the wages and conditions of the new role, any changes in seniority, as in work status, the location, any changes to working hours, and the level of job security. In the cases of where a business has obtained employment for a business, they will also look at whether or not there's going to be continuity of service. So whether or not the new employer is going to acknowledge or take on the sick leave liability, or the old employer might pay out to the new employer the sick leave entitlement, so that person had access to that, as well as things like notice. So those can be considerations of the Fair Work Commission, and the variation will be a balance that the Commission will make between the roles. Michelle's got a question here around is redundancy, or are those redundancy payments the severance payment? Redundancy payment, severance payment, those are synonymous terms. We mean the same there. Severance being just the specific entitlement at the time of redundancy, if the business is larger than 15 employees. One of the, I guess, is a bit of a repeat from what we were talking about earlier in terms of the small business threshold to a certain extent, and a topic we've sort of discussed. So there's a small business threshold component if the employee has less than 12 months service, casual and apprentices. One of the things to watch out for here is the legislation fine print, and that is around what happens where a business has, say, 16 employees, makes 2 people redundant, pays them the severance entitlement, and then immediately commences another round of redundancies, if you like, and says, well, now we're a small business, so we won't be paying out these remaining 5 workers, perhaps, because they're not entitled to severance, because we're now a small business. So there would be, it's an at-time test, and the Commission, again, will have to make a decision or a determination as to whether or not the timing has been contrived, or whether or not there's been a reasonable period between, say, round 1 of redundancies and then round 2 of redundancies. So an employer would be sort of in their best interest to be looking at that. Typically what an employer does, though, is look, if they have a casual group of workers or the like, they will reduce that area of the workforce first, and then with the view of holding on to the full-time workers. That's the nature of casual employment. It also then gives them the ability to reduce their workforce. Some time later, if work hasn't improved, and I can't give you much more than a sometime later, then the business might then go through round 2 of redundancies, and that might result in those workers being the business now being under the small business threshold. So I guess there's a fair bit there to be brought home. I guess there are some good myths that I've had over the years that sort of help cement some of the curly questions or the loopholes you might think might be swirling around in your mind. Scenarios where the employer says, I still require this work to be done, I just don't need it to be done by this person, therefore it's not a redundancy. And this is an actual example I had with one of our members. They were doing a test and tag, had a test and tag position. They redistributed that test and tag position to a number of other workers. They took that on. They made that test and tag worker redundant, or they terminated their employment. The workers made an unfair dismissal claim, effectively just looking for their severance entitlement because the business was big enough. I had the conversation with the business to say, well, this does fit the definition of redundancy. You've redistributed the work to the rest of the business or to other workers. And the explanatory memorandum to the Act in about paragraph 5,500 or something around there gives it examples where the business has redistributed the work. So that does fall within the definition of redundancy. It also helps us from the concept of someone saying, well, you no longer require the work to be done anymore. That means you can't do electrical work. You just, or that by doing electrical work, you do still require the work to be done. Well, that's not quite right, because if you have 5 workers, but you only have work for 4 workers, you no longer require that person to do the electrical work, and therefore you're reducing the position. You're redistributing the electrical work that you do have to a smaller workforce, that being 4 workers. I've had myths in here around apprentices can't be made redundant, or employers seem to think that apprentices are immune. We're not under a we're not under an indenturing arrangement anymore in training contracts, so that we're not bound to one another with shackles like in times of ye olde times where it was, master and apprentice. It's a training contract, and that training contract can be brought to an end, and it can be brought to an end within the rules and the law, the rules of the legislation, the Fair Work Act. So an apprentice can be made redundant. Still the same requirements to consult. The extra step, particularly or usually, is that the employer needs to cancel the training contract, usually mutually, through the mutual cancellation process, but they still have the same obligations to the apprentice with respect to consultation and notice, but no, they won't be entitled to the severance component. The other one that can be a more delicate scenario is a worker who is pregnant or who is on parental leave, that they can't be made redundant and therefore they somehow are preserved. It may not be the case that they're made redundant at that time. We might be looking at the position of the business when they are looking to return from that leave, but they're not immune. But typically, if someone was on parental leave and it was halfway through, perhaps, and the business decided it didn't need an office position anymore or a tradesperson position, we wouldn't make a decision to make that worker redundant until they looked to return to work at perhaps the 12-month mark, and we'd see what the business was doing then. It would be worthwhile, though, to consult with that worker at the time, particularly if other workers are being made redundant, just so that they're aware of what the position of the business is at that time, and that we can say, well, look, no decision of any kind really has been made with respect to your decision. If all things were as they are now, we would likely be talking about a redundancy here as well, but you're not due to return to work for 6 months. Perhaps a lot might happen to the business, and we hope so, that it improves in the next 6 months, and be able to return to your position. But it would be worthwhile to consult with that worker so that they're not under any illusions as to what might be happening within the business. The second last point here is one more around what is the meaning of notice and giving someone notice, and or what it means by to consult. It's not going to be good enough for the business to simply say, "Oh, I talked to workers and said that things were quiet. I said to Jono, look, mate, you should probably find a new, should be looking elsewhere." That's not notice. You haven't told the person you're going to end their employment. It's also not consultation. Um, it might be a candid conversation you have, but in no way does it tick off or represent your obligations with respect to the Act. We need to be a little bit more formal than that, particularly when it comes to managing these obligations around consultation. The last one there, not offering ongoing employment to an apprentice, is a redundancy. So when an apprentice completes their apprenticeship, that's the end of their fixed term arrangement. An employer doesn't have an obligation to offer ongoing employment to an apprentice. Where they choose to not offer ongoing employment, perhaps because there isn't the amount of work that they would like to have, that just simply represents an end to their fixed term arrangement. There's no severance attached. If the ending of the apprenticeship and the termination of their employment happens at the same time. If the employer has offered ongoing employment, even if it's a couple of weeks, then we're no longer talking about the worker being completed at the end of their apprenticeship. They've stayed on as a tradesperson, and now we're in this. Now we've got ongoing employment. And just to be clear, the apprentice period of their employment, and then perhaps this new shorter period of them as a tradesperson, that all counts as one period of service. They are not. Their employment doesn't come to an end at the end of their apprenticeship and then start again at the end with the tradesperson. It's all one period of employment, and therefore any severance components or notice entitlements that we'd be looking at would be looked at from the date they started as an apprentice. Last point there might be a bit contentious. It's a common myth still, so if there are questions around that, certainly happy to have a chat about those. But in short, that's I guess the ins and outs of what I'd say is the minimum bits and pieces you need to understand with respect to the legislation and your obligations around redundancy. Consultation is typically the area that employers miss, and one that they need to ensure that they do. It's a critical step in order to be able to defend themselves against something like an unfair dismissal claim or a general protections claim. I've just today had an unfair dismissal claim for a member because they have the worker is contesting the redundancy scenario. They say that there were other workers brought on after their employment. They were made a scapegoat. The employer in this instance gave a consultation, did go through a consultation process, but it does happen. We're not talking about rainy day events that rarely ever happen. We're talking about very real prospects of people making unfair dismissal claims. So it is an area that an employer needs to be able to defend themselves against, and it might not have been the way it was done to you, or it might not have been the way you've done it in the past, but certainly given the level of litigation that everyone wants to go through, and it's $60 to lodge an unfair dismissal claim and you get that money back, there's not a lot of disincentive for someone to have a crack to see if they can get themselves a bit of extra money for cheap. So we highly recommend that you go through a process there. So if there's not any other questions, I might to pause this. I have made a recording. Hopefully I'll be able to get that up onto the web, maybe through YouTube, for people to look back later. I'll also be able to send you the slides if you're interested. So yeah, I will give you some options there. Thank you very much.